Hello, everyone, and welcome to One Civil Law. And for today's case, we're going to discuss two U.S. Supreme Court cases that just came down yesterday, one relating to ghost guns and one relating to bankruptcy. So on the issue of ghost guns in particular, we're talking about guns that are made by someone at their own house. This typically is done by using what's called an 80% lower. As the name sort of implies, it is a gun lower, which is the registered part of the firearm, that is 80% complete. It is up to the person who receives it to finish that by milling out the components that need to be milled out in order to transform the gun into a working, operating firearm. So you could theoretically have a 0% lower, in which case that would just be a solid block of metal, or you could have 100% lower, in which case that would be the finished product. So that's what you're measuring. How complete is it versus raw block of metal to finished product, okay? And the 80% lower is 80%, as the name sort of implies. And these guns are made by people at their own house, and they're not required to be serialized. So there's not necessarily any record of them existing. So they're called ghost guns. And of course, these days with 3D printing in place, some components can be manufactured using 3D printers as well. So this is the thing the government is trying to regulate, and this is the decision that we're talking about. So let's go ahead and discuss this. We are in the case of Bondi as the Attorney General in her official capacity versus Vanderstock. So let's discuss the case. The Gun Control Act of 1968 requires those engaged in importing, manufacturing, or dealing firearms to obtain federal licenses, keep sales records, conduct background checks, and marks their products with serial numbers. So if you're in the business of guns, it's regulated, as you might expect. So you're a manufacturer, you're an importer, you're a licensed seller, an FFL. Okay, you're one of these people. Then those guns have to be marked, serialized, traced, recorded, so forth and so on. Great. The Act defines firearm to include any weapon which will or is designed to or may be readily converted to expel a projectile by act of an explosive and the frame or receiver of any such weapon. So the frame itself, the lower, is the serialized part, typically, because it legally qualifies as a firearm, as we just read. Recent years have witnessed profound changes in how guns are made and sold, with companies now able to sell weapon part kits that individuals can assemble into functional firearms at home. These kits vary wildly in how complete they come, typically 80% lower, as I mentioned, and in how much work is required to finish them. Sales have grown exponentially, which law enforcement agencies report dramatic increase in untraceable ghost guns used in crimes, from 1,600 in 2017 to more than 1,900 in 2021. What kinds of crimes is not specified here, incidentally, but that's what they said. In 2022, the Bureau of Alcohol, Tobacco, Firearms, and Explosives adopted a rule interpreting the act to cover weapon part kits that are designed to or may be readily converted to expel a projectile and partially complete disassembled or non-functional frames or receivers, the 80% lowers, for example. Before ATF could enforce its rule, gun manufacturers and others just filed what they described as a facial challenge under the Administrative Procedures Act, which is sort of the law that defines how agencies make rules, and comes up a lot with respect to agencies, because the APA says how you have to go about making the rules, and that's what that law does. Arguing that the Gun Control Act cannot be read to reach weapon part kits or unfinished games and procedures. So they're arguing the statute doesn't cover this domain. Okay. The district court agreed and vacated the rule. The Fifth Circuit affirmed, holding the relevant law categorically does not reach weapon part kits, regardless of completeness or ease of assembly, and the relevant law reaches only finished frames and receivers. So we're just doing a straight statutory interpretation question. What does the law encompass here? All right. The Supreme Court says, hell, the ATF rule is not facially inconsistent with the Gun Control Act. So no, this is a valid interpretation of the Gun Control Act according to the Supreme Court. Okay, the relevant law provisions addressing weapon part kits are not facially invalid under the law. That subsection contains two requirements. A weapon must be present, and the weapon must be able to expel a projectile by action of an explosive designed to do so or susceptible to ready conversion to operate that way. Some weapon part kits meet that description. Again, by the way, some being key. This is a facial challenge, not an as-applied challenge. So as I'm sure the Supreme Court is going to discuss in a moment, under a facial challenge, it will only be struck down if there is no valid use or no valid application, or maybe some very, very small application. So we're only going to strike down something facially if, let's say, 99% of the time, it doesn't work, right? If there's more than 1%, let's say, valid, then we're not going to strike something facially down. Facially basically means it's not valid in all or essentially all applications. And so they're saying, well, this is not invalid as all or essentially all. That doesn't necessarily mean that all kits can be regulated by the rule. There would still be as applied challenges, and God knows I'm sure there will be. But there is at least some, or a more than minimal, more than de minimis, I think is the right way to think about it, a more than de minimis number of kits that would fall within the scope of the statute as the statute's written. So that makes sense to me. All right, so the Supreme Court continues. Consider, for instance, Polymer's 80s buy, build, shoot kit, which contains all necessary components to build a semi-automatic pistol and can be assembled in about 20 minutes using common tools. Debatable, depends on your level of skill, but okay. I don't think the time necessarily qualifies. I mean, unless it was unduly burdensome. So even if 20 minutes isn't the right number, if 2 hours was the right number, even if it was a day, that's probably still sufficient. So I'm not sure it turns on the 20 minutes thing. The kit qualifies as a weapon because artifact nouns like weapon often describe unfinished objects when their intended function is clear, as with a disassembled rifle. So for example, if you just literally took a rifle and that was made 100% ready to go, and you just took it apart into all of its components, it's still a rifle because it can be readily converted into putting a rifle because you just put it back together, right? Great, so that makes sense. The statute treats starter guns as weapons, though they require conversion work. So again, like how close does it have to be, right? If you had 100% and you just broke it down to parts, that qualifies. So how close does it have to be? Not quite specified here, but doesn't necessarily have to be completely finished. The statute text contemplates that some things short of fully operable firearms qualifies as weapon. The kit also satisfies the second statute requirement, as requires no more time, expertise, or specialized tool to complete than a starter gun, which the statute treats as readily convertible into a functional firearm. While other kits may be so incomplete or cumbersome to assemble they cannot fairly be described as weapons capable or ready, the facial challenge fails because kits like the Polymer 80 do qualify. So again, not necessarily all kits. And of course, then we get into the fun issue about exactly where the line is, and no one's quite sure exactly where the line is right now. No one's quite sure what the answer to this question is at the moment, because people have been doing the 80% lower thing, thinking that worked. And now we're like, well, that isn't good enough. So it's like 60% lower? Is that good enough? 20% lower? What is the standard? No one's quite sure. That's why we're going to have to figure this out through a whole bunch of as-applied challenges, and then we'll figure out the delineations. C&T Design and Arms said the ATF defined readily convertible as 8 hours in the machine shop. That seems like a plausible definition. Yeah, that seems like a workable definition. 8 hours in the machine shop. I don't think I have a particularly difficult time with that being as readily convertible. That seems like a plausible definition to my mind. The relevant section's treatment of partially complete frames and receivers is also not facially invalid. 8 hours is an attorney in machining. Now, it depends what you're trying to do, I suppose. But I don't know. If you're a hobbyist and you just have a free day, and you can get access to a machine shop, then, I don't know whether it's a lot of time or not. Doesn't sound that bad to me. But, I've never really tried it, but 8 hours doesn't sound like an unduly lengthy amount of time to me. In a full machine shop, you could melt down cans and make a gun? Sure. Could you do it in 8 hours? Then we'll have a discussion, I guess. Section's relevant treatment of partially complete frame and receivers is also not facially invalid under the relevant law. Like weapon, the artifact nouns frame and receiver may describe not yet complete objects. That statute uses the term to encompass some unfinished items elsewhere as the relevant serialization requirements for incomplete weapons, silencers, and destructive devices. ATF for decades has interpreted the statute to reach some unfinished frames and receivers, and even plaintiffs concede they have no quarrel with the ATF's prior practice of regulating those products. Accordingly, the statute authorizes ATF to regulate at least some incomplete frames or receivers that take minutes of works with common tools to complete. While other products may be so far from finished, they cannot be fairly described as frames or receiver, the facial challenge fails because the statute plainly reaches some partially incompleted items. Fair enough. 8 hours is too long. You, the deli, can get a ready-made sandwich. Those took 20 minutes to make at most. Well, I don't think that makes sense. I don't think that makes sense. I don't think that just because a gun takes longer doesn't necessarily mean it's not readily convertible within a particular time frame. Not all things are necessarily as easy as other things. But that isn't the question. We're trying to decide whether or not, basically a person with, let's say, average skill set could convert this using, let's say, reasonably available tools. So we could even define it that way. Maybe the ATF's definition is too broad. Maybe that's too broad, and maybe that's fair. So maybe a better definition would be like, okay, a person of average skill, average machining skill, right? So a hobbyist maybe is a person of average machining skill, an average machining skill with average, reasonably available tools, like the kind of thing you might be able to find, for example, at some sort of cooperative or some shops make their equipment available to people, or stuff you could rent perhaps. Maybe that makes it readily convertible. Maybe that's the definition. But we're just playing with, at this point, we're just playing with boundary markers. We're not really having a real disagreement. It's like, okay, I think 8 hours. If I said I think 4 hours, we're not really having that much of a fight, right? We're arguing over the margins. We're not really arguing over something of real weight. So if you want to say that you think the ATF definition is too long and you think, I think it should be an hour, it's like, okay. I mean, at that point, you're not really having that big of the fight with the ATF. You're having a much more modest fight by comparison, at least in my opinion. Yeah, you're a CNC machinist. Yeah, I would talk about the average machinist, because the average machinist, right? So what you could do and what the average person could do. So the ordinary, normal, average machinist of ordinary, normal, average skill. The man on the street, the machinist. Take the man on a bus and make him a machinist. What can he do, and what would it be reasonable for him to be able to pull off? And that's the kind of thing that we're talking about. We're not talking about. We're not talking about the lowest case, and we're not talking about the best case. The average, normal, competent machinist, the 50% guy, what can he do? That's the kind of thing we're talking about. CNC machinist is not a public skill. Well, no, it would be the average person with the skills. That would be correct. That's always the relevant definition. That's true in any domain. This is not unique in this respect. So if you wanted to know, for example, like anything, like a barber gives you, it's the same standard basically you would apply in negligence. So you talk about this all the time. You talk about the average barber, you talk about the average plumber, you talk about the average whatever, right? You talk about the average normal whatever as it relates to that definition, because that's the relevant thing that you're measuring. And so that is the relevant domain. And you would do that in any other context. This context is not special in that respect. So. But interesting comments nonetheless. Like weapon, the artifact terms name and frame and receiver may describe not yet complete objects. The statute uses these terms to finish undescribed objects elsewhere. Plaintiff's argument about linguistic differences between subsections A and B, potentially unintentional consequences under the National Firearm Act are unpersuasive. The government represents that AR-15 receivers do not qualify as machine gun receivers, and this court's analysis of the Gun Control Act does not suggest ATF has authority to regulate them as such under the NFA. So a standard AR-15 receiver is not a machine gun receiver, at least typically speaking. but some might be designed to be, but not as a categorical rule. Neither the rule of lenity nor constitutional avoidance applies here, whereas statute text, context, and structure makes it clear it reaches sub-weapon part kits and unfinished frames of receivers. Gorsuch delivers an opinion of the court, my boy, in which Robert, Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson concur. Thomas and Alito dissent in a 7-2 decision. So that makes perfect, reasonable sense. And I don't necessarily have a problem with that under the statute. Now, of course, because this is regulated by the ATF, of course, could change its regulations. Of course, it could always change them back under a future administration. So if you're not happy with this, the easiest way to fix this problem is to petition Mr. Patel, who at least for the moment is the head of the ATF, in addition to being the head of the FBI, because he does have enough to do with his time. The easiest way to fix this problem is to petition Mr. Patel to use the Administrative Procedures Act to change the regulation. And that would solve the problem. Or, of course, you could get Congress to pass a statute that also would strip the ATF of authority, or just abolish the ATF altogether, depending on what you're trying to do. So those would be the easiest ways to solve those problems. But I don't really have a problem with this. This seems fine. This seems fine. All right, great. Let's discuss this bankruptcy case, which will probably be less controversial. All right, this is the case of United States versus Miller. This case concerns the power given a bankruptcy trustee to set aside or avoid certain fraudulent transfers of debtor assets. Yeah, bankruptcy trustees have lots of power. They have lots of power. If you want to say like who is like the single most powerful person, bankruptcy trustee it gets up there on the top of the list. Like what profession has the most power? Bankruptcy trustees have a lot of power. It's a lot. Anyways, so we're discussing their particular power to set aside or avoid certain fraudulent transfers of debtor assets. The respondent is a bankruptcy trustee of a failed Utah-based business whose shareholders misappropriated $145,000 in company funds to satisfy their personal federal tax liabilities. They stole from the company till, man. Don't do that, man. They don't do that. Respondent filed an avoidance suit against the United States seeking to claw back the misappropriated funds for the benefit of the bankruptcy estate. He filed the action pursuant to relevant law, which allows a trustee to avoid any transfer of interest of the debtor, which is avoidable under applicable law by a creditor holding an unsecured claim. But to prevail under the relevant law, a trustee must identify an actual creditor who could have voided the trustee transaction under applicable law. So the trustee in this particular respect doesn't have more power than the creditor does because it was fraudulent, and fraudulent things are always void. So, if you sent me a bill, for money I don't owe you, it's fraudulent, or there was fraud in the inducement in the thing. It's like, I don't owe you the money, right? You tricked me. You defrauded me. I don't owe you the money. So I'm not going to send you the money. Screw you. And in this respect, the trustee is now just taking the place of the creditor. He's just saying, okay, this is fraud. I'm not going to send you the money. Screw you. Okay. But he has to identify who this person is. In this case, respondent invoked Utah's fraudulent transfer statute, which gives creditors a cause of action to invalidate certain transfers by a debtor as the applicable law underlying the claim. So he's like, okay, fine. I have some Utah-specific authority relating to this, which of course makes sense because typically what debts are valid or not are typically going to be decided by state level law. Right? If you're talking about what makes a valid contract, for example, that's state level law. And so he's like, okay, this is not a valid thing, and I'm using Utah specific law to get there. Okay, that makes sense. The government argued that the respondent's claim failed because the respondent could not identify an actual creditor that could have voided the fraudulent transfer because sovereign immunity would bar any such Utah cause of action against the government. So fair enough. So I'm the federal government. You can't use this federal statute. You can't use this state level statute against me. Makes sense, right? Makes sense. The money that you owe to the federal government. So Utah law can't speak to the validity of my claim because the federal government is not controlled by state level law. Okay, that makes sense. The bankruptcy court disagreed, concluding that the relevant section of the Bankruptcy Code, which waives sovereign immunity with respect to some provisions, including some other provision, also waives immunity for the Utah cause of action nested within it. So, of course, sovereign immunity can be waived by the federal government. And so the court said, well, in principle, yes, but in reality, in a particular statute, the federal government has said it can be sued for this reason. So you've already given up that issue. So it can go forward, even though it's state laws. The federal government can bind itself to state law. Sometimes it does. It can choose to do that. And if it does it, fair enough. Then the state law applies. Cool. So the lower level court said the state law applies because you basically chose to bind yourself to it. Congratulations. That makes sense. The district court adopted the bankruptcy court decision and the 10th Circuit affirmed. All right, so this is pretty easy question, right? This is, did the federal government waive its immunity? Did the federal government say, yes, you can sue me for this reason? That's pretty easy. Hell, it's not. It's uneasy to understand. Actually doing it is a whole nother set of problems. So when I say it's easy, it's like I understand the problem. Actually working through the analysis, not necessarily easy. Let's read what we got. The relevant section sovereign immunity waiver applies only to the claim itself and not to state-related claims nested within the federal claim. I mean, fair enough. This is straight statutory interpretation, no muss, no fuss. This is straight statutory interpretation, easy, right? We've got a federal statute. We've got a federal thing that says, yes, I, federal government, waive my immunity with respect to this section, but only with respect to that section and not to a state level claim that's somehow nested within it. So I didn't consent to the state level thing, even though you tried to color it as a federal thing. So no, doesn't work. This is easy peasy statutory interpretation land, comparatively. The dispute turns on the interplay between two relevant sections of the Bankruptcy Code. One section of the code provides that the government's sovereign immunity is abrogated with respect to a list of code provisions, including sections 554. Well, that makes it easy, right? I have sovereign immunity. No, you don't. Why not? Section 106 says you don't with respect to 544. Oh, okay. So I've waived immunity with respect to 544. Cool. Respondent contends that Section 106 also waives sovereign immunity with respect to whatever state-level cause of action a trustee might invoke as the source of the applicable law for the 544 claim. But that result would transform 106 from a jurisdiction-creating provision into a liability-creating provision, which the court, with traditional understanding of sovereign immunity, waivers. Essentially, basically, in so many words, the federal government can waive sovereign immunity, but we're going to interpret that comparatively narrowly. We're only going to say that we're not going to read more than's there. So you can't really stretch out the statute or stretch out the waiver. The waiver only goes as far as it does and no further. So that makes sense. Pretty typical. As the court precedent explains, sovereign immunity is jurisdictional nature and operates to deprive courts of power to hear suits against the United States absent consent. Waivers of sovereign immunity function simply as prerequisites for jurisdiction. They don't create any new substantive rights or alter any pre-existing ones. Yeah, so sovereign immunity is basically, can I be sued? Not necessarily for what. Like, does this court have power over me at all? Has jurisdiction been established for the record? And so forth, and so on. Respondent attempt to leverage the waiver of immunity, the statute granting jurisdiction, into an affirmative expansion of the trustee's avoidance powers under 544 conflicts with the course of understanding of sovereign immunity waivers. Again, waivers, at least with respect to sovereign immunity, are going to be interpreted narrowly. Makes sense. Section 106's text, context, and structure make clear it does not operate to modify the relevant substantive requirements. Indeed, Section 106A5 expressly provides nothing in this section shall create any substantive claim for relief or other cause of action not otherwise existing under some sort of law. Well, that sort of clears that issue right up, right? This is not substantive. This is just jurisdiction. It's like, yes, you can sue me, but for what? A whole nother set of problems. Yeah. That language directly refutes respondents' argument that Section 106 sovereign immunity waiver extends to both causes of action and its elements. Construing the relevant law to modify the elements of 544 claim would give the trustee a substantive claim for relief against the government that does not otherwise exist under 544 or Utah law that would then be in conflict with federal law. Once again, the federal government can bind itself to state law. Sometimes it does. Most of the time, not so much. But unless it does it explicitly, we're not going to read it. We're not going to read more than is there. Totally logical. Section 544's text and structure reinforces the conclusion. Unlike 544B, 544A has no actual creditor requirement and thus permits a trustee to invalidate certain transfers that a lien holder could have avoided whether or not such a creditor exists. So in some situations, we're not even talking about a creditor. We're just talking about a transfer, right? I'm just going to send you money, not because I owe you money, but for other reasons. And I can void that too under some circumstances. Okay. This contrast reflects Congress' deliberate choice to tie a trustee's right under subsection B to the rights of an actual creditor under the applicable law. Eliminating actual creditor requirement would upend decades of practice and precedent, recognizing that 544 merely empowers a trustee to step in the shoes of a creditor, subject to the same limitations to defense that would apply to the creditor outside bankruptcy. I understand all these things. This makes total sense. In this particular respect, the trustee is just taking the place of the creditor or creditee or whichever it is, depending on the frame of reference. They're just stepping into the shoes. And in this particular domain, they can do exactly what the person could do, which again, if it were me and you, right, if it were fraud, I don't have to pay you money. You have a signed contract. Yeah, but it was fraud, so screw you. I'm not paying you. Now, we might go fight about it in court, but assuming I'm right, then I'm right. If it was fraud, I don't owe you a dime. All right, it was a contract for an illegal thing. I don't owe you any money. Any number of examples. Or, there was a transfer in place and I want the money back. Maybe I accidentally transferred the money to you. It wasn't intentional. I want my money back. You would have to give me my money back. Because it was not intentional. It wasn't a gift. I didn't intend to make the gift. You're just in possession of my property. Please give it back. That kind of thing. Yeah, it makes sense. I buy all this. No problem. This is easy enough. Finally, even if the language and logic of 544 and 106A permitted respondents' broad reading of sovereign immunity waiver, the court's precedent would still foreclose the reasoning. The court's precedent require construing sovereign immunity waivers narrowly, with any ambiguities reflected in the face of the sovereign. As I said, yeah, it's like we're going to interpret these things narrowly. We're not going to go beyond the page. Respondents assert that 106A's use of the phrase "with respect to" shows Congress's intent to abrogate sovereign immunity for all subjects that concern or regard listed provisions, including the meaning of the applicable law in 544. These people are really stretching hard. Respondents' reliance on dictionary definitions in cases that adopt capricious readings of phrases similar with respect to cannot support his argument, as those authorities all examine those terms in very different statutory contexts. Respondents' textual arguments thus flout the fundamental canon of statutory construction. The words of a statute must be read in their context with a view in their place in their old statutory scheme. So it's like, yes, I know the statute used the same words, and it's not necessarily unreasonable to believe that the words would mean the same thing that they do in other statutes. That's not unreasonable to think, but it isn't necessarily true. The words of the statute have to be understood within the statute's context. Other statutes and language there too can be informative, persuasive, but not necessarily controlling. So, makes sense to me. So far, so good. This canon carries particular force when constructing phrases that govern conceptual relationships like "with respect to," whose meaning inherently depending on their surrounding context. I mean, that much is definitely fair. "With respect to" inherently is like, well, it's respecting something, so it's based on context. Of course it is. As set forth above, context decides against this reading. Respondents' appeal to 106 enactment history is similarly unavailing. Since its adoption in 1978, 106 has always been understood to provide a limited waiver of sovereign immunity in bankruptcy cases, designed to achieve approximately the same result that would prevail outside bankruptcy. Fair. Nothing in the 1994 amendments to 106 dislodged that original understanding. In any event, the legislative history cannot support waiver where the language of the statute does not clearly do so. Respondents' remaining argument lack merit. First, this court's interpretation does not render 106A's waiver meaningless with respect to 544. Section 106A enables trustees to prevail against the government under 544A, which has no actual creditor requirement. Because federal tax law separately provides that tax liens held by the federal government may be invalidated under particular circumstances, see some other section of law, 106A allows trustee to avoid transfers of these tax liens. Section 106 also grants federal courts jurisdiction to hear 544 claims against state governments that have been consented to be sued under their fraudulent transfer statutes. Second, the court rejects respondents' argument that because 106A1 refers to 544 as a whole rather than by subdivision, the waiver must be construed to give substantive effect to all 544 subsections. Many of the other 58 bankruptcy code provisions listed as a whole in 106A1 include subsections that plainly do not implicate sovereign immunity at all. So they're like, yeah, you should read, it says just 544, so you should read the whole thing. And they're like, well, it says a whole bunch of statutes, and when we read those whole things, that isn't how that goes. So it doesn't make sense to do it here. Read it in kind. Third, reasonable reliance on Kurtz to support his argument that Congress sometimes waives sovereign immunity while simultaneously establishing a new substantive right is unavailing. Kurtz involved a statute that bear little resemblance in text, structure, operation of 106A, and indeed explicitly authorized claims against the government. Nothing in Kurtz suggests the court should presume in the absence of explicit statutory language that Congress has waived statutory immunity. Finally, the court declines to respondent's invitation to affirm on alternative grounds, leaving the court below to decide whether respondent may pursue those arguments on remand. Jackson delivers the opinion of the court with Gorsuch in sole dissent, an 8-1 opinion. And because Gorsuch is my boy, I would like to at least skim Gorsuch's argument to see if he has a better idea, because he's my boy and I like Gorsuch. So we're going to at least skim some of the dissent and see if he makes a better case, because that summary sounded pretty persuasive to me. But maybe Gorsuch has a better idea. Let's see. All right, it's only 2 pages. Okay, this is going to be short. I'll read the whole thing. Gorsuch dissents. The court has often warned against confusing the doctrine of sovereign immunity with the requirement that the plaintiff state a cause of action. Okay, yet to my eyes, the court decides today suffers from a confusion. Okay. 3 statutory provisions are relevant here. First is 11 U.S.C. 106A1, which waives the government sovereign immunity with respect to Section 544 of the Bankruptcy Code. Okay. Second is 554B1, which empowers a bankruptcy trustee to invoke the rights of a creditor holding an unsecured claim to set aside any transfer that's voidable under applicable law. Okay. And the third is Utah's fraudulent transfer statute, which here supplies the applicable law for the purposes of this law. Okay, as I see it, those provisions play out this way. Under the Utah statute, a transfer is voidable if, after creditor's claim arose against a debtor, the debtor made the transfer without receiving reasonably equivalent value in exchange and was insolvent at the time. So I can claw back money that I sent you. Right? So I sent you money without anything in exchange, and I was insolvent, in which case you have to give me the money back. It wasn't money for goods. It wasn't money for services. It was just money that was being sent from a person who's bankrupt. Give the money back so that we can distribute it according to the bankruptcy code, not according to your whims. Perfectly reasonable. Notably, no one before us disputes that these conditions are satisfied here and a good fraudulent transfer claim exists. Thus, under applicable law, the relevant transfers are voidable, and the bankruptcy trustee can use the relevant law to set them aside. That remains true even though the trustee must sue the United States to void the relevant transfers, because 106A1 bars the government from raising sovereign immunity defenses in the trustee's action. The court worries that my line of thinking would modify the elements of a 544B claim. More exactly, the court observes that if the creditor sued the government directly under Utah's fraudulent transfer statute, the government could interpose a successful sovereign immunity defense and the creditor would lose. All right, so This gets a little bit into the question of whether or not the bankruptcy trustee is merely stepping into the place of the creditor or whether or not it's something special, because often the bankruptcy trustee has powers the creditor lacks. The way the majority described this particular section is they said, at least with respect to this particular thing, the bankruptcy trustee is in the same exact position as the creditor. They just simply step into the shoes of the creditor. And so they can do what I could do, right? I'm bankrupt. Can I do it? Yes. Then the bankruptcy trustee can do it. Can I do it? No. Then the bankruptcy trustee can't do it because the bankruptcy trustee is stepping into my shoes, at least with respect to this particular domain. But Gorsuch seems to be disagreeing with this concept. He seems to be saying that no, the bankruptcy trustee doesn't merely step into my shoes. He gets some extra power on top of that, which isn't exactly unheard of for the bankruptcy trustee. So he has more power than I would have, which, fair enough, because the bankruptcy statute is a statute written by Congress under its authority to regulate bankruptcy and set out the rules for bankruptcies. And so Congress can create rules that would, in fact, override state law because they have the power to define the uniform rules for bankruptcy under the Constitution. So it may very well be the case the bankruptcy trustee has more power than he has because he doesn't necessarily need to rely on state law. He has federal law to go to, and he can do special things because he's special and important. All right, anyways, pressing on. So that seems to be the issue here. All right. And the court fears reading Section 106A1 to allow the bankruptcy trustee to bring the same claim under 544B1 would be impermissibly give the trustee a substantive claim for relief against the government that does not otherwise exist. Okay. It seems to me, however, the court conflates two different things. Whether pursued by a private creditor or a bankruptcy trustee, a good substantive claim for relief exists. No one disputes the fraudulent transfer took place. The question before us is distinct. Can the federal government defeat the claim by raising the affirmative defense of sovereign immunity? With respect to a private creditor pursuing relief in state court, the answer is yes. With respect to a trustee pursuing relief in a federal bankruptcy proceeding, the answer, thanks to 106A1, is no. Admitting that much does not modify the elements of any claim or create any substantive claim for relief that does not otherwise exist. It merely acknowledges that in one setting, but not another, Congress has chosen to waive affirmative defenses to an otherwise valid claim. Which, fair enough. Congress can absolutely do that. They can waive sovereign immunity or not based on pretty much any criteria they want. For these reasons, I agree with the majority of circuits to have considered the question that bankruptcy trustees may avoid these fraudulent transfers. As the court concludes otherwise, I respectfully dissent. Very, very technical. I like it. And I like technical, and I like exact statute reading. It pleases me. So in order for me to try to decide which of these ones I like best, I'm going to go look it up, and we're going to decide it together. So I need to pull up two things. I need to pull up 11 U.S.C. 106. Okay, and how does that look in my page when I pull that up? Take a look, it's in a book, reading rainbow. Friends to go, wave to go, reading rainbow. Reading rainbow. All right, let's see. All right, so okay, make this a little bit bigger. Cool. All right, so that's 106, and I also need 11 USC 544B1. Okay. Dun, 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 dun. Dun, 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 dun. Get from these people. Five, 4, 4. Come on. The estates. So fancy. Trustee is lien creditor. Okay. Okay, so I need this. All right. So I need 106A1 All right, so let's start with 106A1. This is 11 USC 106, waiver of sovereign immunity. A, notwithstanding an assertion of sovereign immunity is abrogated as to a governmental unit to the extent set forth in this section with respect to the following. And then it sets those statutes. So I'm like, okay, waive sovereign immunity with respect to 544. If there's 554, it's on the list. Great. All right, and then I need 544B1. Okay. Let's take a look. 11 USC 554. Trustee is lien creditor and successor to certain creditors and purchasers. And it was B1. Yeah. All right. Except as provided in paragraph 2, the trustee may avoid any transfer of any interest, the debtor on a property or obligation incurred by the debtor that's voidable under applicable law by a creditor holding an unsecured claim that's allowed under section 502 of this title, or is not allowable only by section 502E of this title. Well, is it allowable under 502? I'm going to assume yes, because no one's discussed it. So I suppose this boils down to the question of when it says under applicable law. When it says under applicable law, what law does it mean? And I'm not sure I necessarily agree with Gorsuch, because I don't know that I would read under applicable law as including state level law. I mean, I would assume, because you normally read a statute, of course, within its own context, as we discussed earlier. You read a statute as a whole. And so when it says under applicable law, I would assume it's either referring to the rest of the bankruptcy code or perhaps the rest of the US code, but not necessarily state level law. I wouldn't necessarily think under applicable law include state level law unless they said that. So I think yeah. Gorsuch just says it's the applicable law, but he doesn't really justify why. He just says it is. And that seems to be a little odd to my mind, because again, it's a question of separate sovereigns. It's a question of, if the state level wrote, applicable law, I wouldn't think federal law necessarily comes in unless they wrote it that way. And I don't think the state level law, is MGL law still here? Or did he scamper off? Is MG law still here, or did he scamper off? I'd be interested in a second opinion. I wonder if the majority justifies. Well, they don't even get to the question, because they don't even try to decide whether or not the Utah law is the applicable law. I don't think, if I understood the syllabus, they don't even get to that issue. So no one is trying to decide. Everyone seems to take it for a given, I think, that it's the applicable law. Maybe they cite a case that makes that clear, that it's the applicable law, because that would be interesting if there's a case that says that. Okay. Although the term applicable law can technically refer to any state or federal law outside the bankruptcy code, trustees typically rely on state statutes to supply applicable law. Maybe it's just the way it's been. It's an applicable thing. So maybe it's just understood to include state level law. That's just been the history of the thing. Yeah. I need to read it in context with 11 USC 541. Okay. Property of the estate. Any particular section of 541 that you want to bring to my attention? Because it's not popping out on the page of me. Is there any particular section of 541 that you want to bring to my attention? Yeah, I'm going to need a citation to a more specific part so I can understand what you want me to think about. Gorsuch is correct. 106A waives sovereign immunity defense in the case of bankruptcy is distinct power not available to creditors under state law. Fair. I think that makes sense to me. Yeah, I think it does waive it with respect to the section. This seems to be a transfer, not a creditor situation. Now I'm kind of confused by the majority opinion because it's like it seems like they're conflating 544A and B. Yeah, I know MG Law's back. I'm glad that he's here so we can help me think through this as I need further help. Because it seems to me that the majority might be conflating 544A and B. So I need to, because I was reading it with respect to does state law apply. So now I need to skim it with respect to the other thing. All right, let's see. Apparently, Supreme Court disagrees. Yeah, I understand that, MG Law. I mean, I'm still trying to figure out what I think, and I have no problem disagreeing with the Supreme Court. I'll tell you that if I think they're wrong. I'm still trying to figure out which way I want to go on this issue. The actual creditor requirement serves as an important check on B. Actual creditor requirement? What the hell? By a creditor holding an unsecured claim. Okay. So this go back to whether if there's no creditor, sorry, I'm sitting here in silence. I'm trying to read this and I'm trying to read it fast, and that takes a lot of my mental energy. So it's not necessarily good watching as I'm reading. All right. We conclude that 106A does not alter the substantive meaning of 544B's applicable law clause, providing a waiver of immunity that would not otherwise exist under that external source of law. Oh, I don't buy that, I don't think. Yeah, I'm skimming this, and maybe I'd think differently if I was really reading this all the way through as I'm skimming this. So maybe I'm not being completely fair to the majority, but I think Gorsuch's argument seems a little bit better on balance. Okay. Yeah, I think as I sort of skim this, I think on balance, I think I'm going to go with Gorsuch's opinion. But very, very interesting. It's a very interesting question on like this is doing statutory interpretation at a pretty advanced level, and I do appreciate that because it's really trying to get me to think. It feels like a on the more complex side of a statutory interpretation question, particularly when you're cobbling it together with sovereign immunity, which naturally, at least to my mind, according to the relevant law, we want to interpret the sovereign immunity relatively narrowly. And so I think I think that's an interesting posture because you could actually get into the issue of whether the sovereign immunity is like a separate question completely. Is it like sovereign immunity is a separate question completely? And this, I think that might be the reason that Gorsuch is reading it differently than me, or different than the majority. I think that might be actually what they're doing. I think Gorsuch is reading the sovereign immunity piece as completely separate and apart from the substantive piece. And I think what is happening is the majority is using the concept of sovereign immunity to also potentially interpret the substantive provisions, or color maybe is a better word, the substantive provisions. So I think they are perhaps changing the way they would read the statutory analysis because it's in this context. They're not divorcing those concepts, whereas I think Gorsuch is divorcing the concepts. And maybe that's what's going on. But very, very interesting, very, very technical, very, very, very cutesy, very demure. All the rest of it, good stuff. All right, good times. I'm going to work on an edited video. And and also at some point, well, I think I'm going to work on the edited video now. And at some point today, I think we're also going to do an oral argument react to the issue relating to the person being deported with respect to, Alien Enemies Act or whatever it was called, as they were trying to debate that issue. And we might get into that somewhat. So that could be fun and exciting. So I'm going to work on an edited video for a while and get back to you. I had fun. I hope you had fun. For the people who joined me, and don't forget to hit the like button. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.